be subject to the Constitution and law. I read it that on that issue, on that subject, there is a law or can be a.
I'm sorry to interrupt you, but I'm trying to understand जिस तरह आप इसको 58 से लिंक कर रहे हैं ना, the practice and procedure parts of this act, आप जिस तरह इससे लिंक कर रहे हैं, तो then necessarily the subject, the legislative power or competence of law in 191 has to be in the broadest possible terms. But that is only possible, it seems to me, if the 73 Constitution had retained what was to be found in 56 and 62, namely specific. आप जरा पढ़ें तो सही, दीजिए साहब को 56 Constitution दें साहब को और 62 Constitution दें. इसमें वो legislative entries जो Supreme Court की हैं वो पढ़ें तो सही ना. आप तो उस चीज को recreate कर रहे हैं indirectly. आप kindly read those legislative entries.
मलूड
आप पढ़िए वकील साहब, पहले पढ़िए तो सही ना. 56 का है 5th schedule.
Is this your argument, Mr. Zaid Ibrahim?
No. I'm trying to. I'll read
Yes,
56 Constitution.
5th schedule. I think it's entry number 16.
Fifth. Yes. Entry number?
I think maybe 16.
16. यहाँ पे.
It's in the Federal Legislative List, 5th schedule. Entry मुझे याद 16 बोल रहे हैं. 16. हाँ 16 है ना, entry 16 देखिए. Federal List, entry 16.
The Constitution, organization, jurisdiction and powers of the Supreme Court, including contempt of such court and the fee taken therein, persons entitled to practice before the Supreme Court.
और अब आप इसकी देखिए 62 Constitution की, वो भी चले ना रहने दें, वो more or less along the same line, just to save time. तो ये जरा kindly बताइए ना कि इसके अंदर जो आप जिस तरह रीड, उसका implication जो है, उसकी जो logical consequence है, does that not revive a legislative entry that perhaps consciously the interim Constitution and the 73 Constitution?
Sometimes, logical consequences flow differently for different people.
I'm waiting for your answer.
My answer is that it does not, in my view. My answer is that I am reading Article 142A as being the powers, that's where the powers stem from, the power to legislate, in relation to matters provided in the Federal Legislative List. The Federal Legislative List, entry 58, and if we can maybe read it perhaps.
Mr. Zahid Ibrahim, could I just to rephrase what you were saying, and if you want to look at it this way, maybe, perhaps, that you start off with 142A, jump on to 58, and now you bounce back to 191. Yes. But this time when you come back to 191, you look at it as an entry because 58 is telling you to look at it. And all you do this time when you read 191, you're looking at the legislative competence only. And you just say there is law mentioned which could do this, and that solves the mystery.
That is what I've been trying, that is my submission.
Are you going in for the part relating to within the legislative competence of Majlis-e-Shura,
yes,
or relate to the Federation? Which part?
The first part.
Fine.
But the first part in itself doesn't give specific direction of competence kis cheez par hai. And as was said earlier,
Competition,
it says it would be anything and everything. So how do you say that from entry 58, matters which under the Constitution are within the legislative competence? So then the question is, where under the Constitution are you getting the competence?
191.
Then you're reading subject to the Constitution.
So what is happening is, as I see it, is that you, as I said, from 142 you jump on to 58. 58 simply says, go back into the Constitution and see if there is any legislative power.
Yes.
I come back to 191, but looking at 191 differently now. I just have to look at the competence, and I see that it says that there could be a law which could regulate practice and procedure. So we just have to look at the subject matter. This time round, coming back after 58, we just look at the subject matter.
That is my reading. My Lord, with regard to...
Mr. Zaid, you can always say, you don't have to agree with me. We are here to hear your contentions.
And I have respectfully
You can.
said it
I mean, are you being polite? You can say, don't need to agree with me.
I think it's fairly
But
clear.
Mr. Zahid, we have to
I've only
understand. We have
expressed...
to understand what you are saying.
Yes, yes, of course. And I've only
We
expressed
may
my
agree with you,
submission.
we may
Of
not
course.
agree with you.
Of course, of course.
But
And
surely a judge sitting on a bench of the court is entitled, when a submission
And I
of high
appreciate
constitutional importance is made,
I appreciate those
to
observations.
appreciate that.
I appreciate
And I
those
think you
observations.
appeared me enough times to know that this is the way
I appreciate those observations.
that's the way I look
चलिए
at
आगे
things.
बढ़े next point
And
please
that's the
चलें
way how...
I'm grateful.
that's
Zaid
the way
साहब आगे
I'm
बढ़िए
grateful,
please
sir. The second point that I wish wanting to submit is that the right of appeal is nothing but extending the jurisdiction of the Supreme Court, which is provided under Entry 55. And why do I say that? First, in relation to extending the power of the Supreme Court, the argument is that this can only be done where there is express authorization. And the counter argument is, where is the express authorization? There is none, and therefore this is a redundant provision. You can't read redundancy into a constitutional provision. So express authorization, I find it in a reading of Article 10A and 2A. And there is a judgment on this that I wish to cite, my Lord.
No, just a minute. Express authorization under Article
10A, right to fair trial,
and Article 2A.
objective resolution.
No, and Article 2A.
Ji.
So is it your case, now these are, as the very appellations A indicate, that these were not there in the Constitution as originally enacted. Entry 55 has never been touched. It remains as it is. So is it your case that prior to these articles being added to the Constitution, the answer would go the other way? Let's look at the Constitution on the commencing day.
Sir,
If suppose on that day or the next day, Parliament had made this law with regard to the right of appeal, there was no 10A then, there was no 2A then, what would you say, what would the answer be?
my answer is, and the question I think is connected to the larger question, that 185 में अपील जहाँ पे कॉन्स्टिट्यूशन ने प्रोवाइड करनी थी, कॉन्स्टिट्यूएंट असेंबली ने वो कर दी. अगर उन्होंने नहीं दी है 184(3) में, too bad. Go back, make a constitutional amendment. That is the argument, right? My contention on that is that the Parliament said, yes, हम 184 में अभी नहीं दे रहे, but हम ये power दे रहे हैं legislature को कि Entry 55 में हम डाल रहे हैं कि you can extend your jurisdiction if at a later stage.
The word used is not extension. The word
Extend.
used is enlargement.
Enlarge the jurisdiction.
Now,
yes.
how do you interpret the word enlargement? As I see it, enlargement is of something which already exists. There is no appeal which exists. So how can it be enlarged?
Mr. Zaid, there could be two interpretations to that. I mean, my loud thinking that enlargement in this entry would have two sets. One is the existing jurisdiction being enlarged. The other is creating a totally new jurisdiction. Still, the Supreme Court's jurisdiction gets enlarged. So it doesn't really matter. The express provision is required for the existing provisions, but for a new jurisdiction, you don't need any.
And when you have two fair interpretations possible, which one do you go to? You go to the one
You see,
where the law will survive.
दो चीजें हैं ना, creating and in creating you are enlarging. Where is the part to create a new jurisdiction?
So that is where enlargement would come in. Most respectfully, sir.
Yeah, agar if we give enlargement a restrictive meaning, then can you give me an example when is it ever applicable then?
Sir, if I may
I mean, I
just,
can't think of a scenario, maybe you can help me think of a scenario. If we give it a restrictive meaning, the enlargement is different from creation of jurisdiction.
But
Then
also-
where will it come into play when, let's say this act did not exist and I asked you, please enlarge the Supreme Court's jurisdiction, what would you do?
It's a matter of semantics, you see. I mean, it's just a word in the sense that suppose if there is an appeal provided, would you not say that the jurisdiction of the Supreme Court stands enlarged? So it's just a word, I mean, to be, and you've read the principles, widest possible interpretation. So
This is
it cannot be
enlargement-
lost in the word.
Enlargement of jurisdiction can be read with Article 175(2) or not, because it is a case of jurisdiction. Okay, no court has any jurisdiction unless conferred by the Constitution, by or under the law. So if you read the enlargement, is it not the appellate forum is not an enlargement of jurisdiction to the original jurisdiction of Article 184(3)?
indeed it is.
So it would be read with Article 175(2) or not, where the powers has been given.
Yes, certainly.
But the law,
My lord, what-
but the law over there would have to be a law that Parliament is capable of making. Which brings us back to the same question.
What will go back to the
But you see, enlargement का तो example 185 में ही दिया हुआ है और वो जो आपके वो थे ट्राइबल एरियाज की enlargement, वो एक्ट का नाम ही था enlargement of jurisdiction. लेकिन आपसे जो मैं सवाल कर रहा हूँ उसका मुझे बताइए ना, आपने अभी 10A और 2A का जिक्र किया. तो I'm giving
और
you
एक
an
चीज
example.
और है
आपने
इसमें
कहा
जाहिद
कि
साहब,
एक-
मिस्टर
एक
जाहिद,
उसके अंदर
आप सुन लें, फिर मैं आपको एक और चीज उसी के
आप
जवाब
उसके
में बता
अंदर जो
दीजिए।
है एक बात आप कर रहे हैं कि जी पार्लियामेंट के पास शुरू से ही पावर था, उन्होंने कहा जब हमारी मर्जी होगी हम लॉ बना देंगे. इज दिस योर आर्ग्यूमेंट?
पार्लियामेंट ने उस वक्त
नहीं बनाया लॉ, ठीक है,
नहीं बनाया,
97
बट ये
but you say that inherent in entry 55 is the power to create an appellate right of appeal in respect to 184(3). Is this your argument?
absolutely yes.
Okay.
My lord,
Now, appeal, is it a procedural matter or is it a substantive right?
it's definitely a substantive right.
It is a
It is,
substantive.
yes.
Learned counsel.
So you
Learned
can create a substantive right by implication.
Not by implication. I'm
Learned
not
counsel.
creating it by implication. I am saying that the injunctions of Islam mandate that you cannot deny right of appeal.
Learned counsel.
And the Honorable Supreme Court of Pakistan says that this is what the injunctions of Islam say.
Which case is that? Which case is that?
Trying to get to that PLD 1989 Supreme Court 6.
But the Honorable
Supreme Court, page 6.
Honorable Supreme Court also says that the lawmaker, if he intended to the constitution makers or framers of the constitution, way of a constitutional amendment,
My
and
lord,
not by
another way of looking at
by stretching entry 55 out of shape.
My lord, another way of looking at it, if we look at 184(3), वो तो इस्तेमाल ही नहीं हो रहा था. Right? Later on, it started, and that is the reason that the Parliament
कब इस्तेमाल होना शुरू हो गया? किस आप बताइए ना, जो इस्तेमाल नहीं हो रहा था. Make your point.
I'm trying.
तो चलिए आगे बढ़िए ना.
Learned counsel.
जरा आप चलते रहे ना, थोड़े आर्ग्यूमेंट्स आपके हम नोट कर लें पहले. जाहिद साहब प्लीज आर्ग्यूमेंट्स तो बताएं.
If I may, this is
Zaid
right.
Saab, as I've understood your argument,
Welcome to the full court.
entry 55 is very crucial. It gives competence to the Parliament in two ways. One is enlarging the jurisdiction. The jurisdiction which already exists, it's enlargement of that. And secondly is to confer supplemental powers. That is in the context of the existing jurisdiction. So, any jurisdiction that exists that can be enlarged. It is not a creation of a new jurisdiction. And it is the existing jurisdiction which is being enlarged. It is unlike Article 185, where the original jurisdiction is of the high courts of other forums. It's only the appellate jurisdiction that has been created and vested in this court. Secondly, coming back to the question, why was there a need? If as interpreted by this court till 1988, if 184.3 had been exercised the powers the way that originally were intended by the framers of the constitution makers, there wouldn't have been a problem. The problem started after 2010, when everyone was speaking about it. The voices came from the lawyers, from everywhere, that the power was being abused, and we need to acknowledge that. So now, in that historical context, merely the jurisdiction has been enlarged.
Indeed, sir. In fact,
Well, the first case that happened under 184.3 was in 1976.
but the
और
floodgates
उसके बाद-
opened later.
उसके बाद 184.3 has been exercised, yes, progressively, but then the law developed.
Yes, of course it did. So, if I may just come to page
But not
12
that it
of
just
this judgment.
started, all of a sudden. I mean, it has been there all along in the Constitution.
Indeed.
And for the first time, the powers were exercised in 1976. And
Floodgates opened later, sir.
yes,
Paragraph.
Mr. Zahid,
page-
please,
ये आगे
Mr.
बढ़े ना
Zahid,
थोड़ा.
जब हम पढ़ते हैं आर्टिकल 175 की क्लॉज 2, तो उससे पता चलता है कि दो किस्म की जुरिस्डिक्शन हैं
जी सर।
जो कन्फर हो रही हैं. वन इज बाय द कॉन्स्टिट्यूशन एंड सेकंड इज बाय द लॉ. तो दो किस्म की जुरिस्डिक्शन हो गई, कॉन्स्टिट्यूशनल जुरिस्डिक्शन और अकॉर्डिंग लॉ की जुरिस्डिक्शन हो गई. अब इनलार्जमेंट अगर इन दोनों में से होनी है, अगर कॉन्स्टिट्यूशनल जुरिस्डिक्शन जो है जो 184 से लेकर 204 तक आती है जुरिस्डिक्शन, उसकी एनलार्जमेंट अगर होनी है, वुड इट बी थ्रू एन एक्ट ऑफ पार्लियामेंट और बाय अमेंडिंग द कॉन्स्टिट्यूशन? और दूसरी, अगर स्टैट्यूट की जुरिस्डिक्शन की एक्सटेंशन होनी है, तो वो क्या उस स्टैट्यूट की अमेंडमेंट के लिए एक्सटेंशन होगी, एनलार्जमेंट होगी, या वो भी एक्ट ऑफ कॉन्स्टिट्यूशन के अमेंडमेंट के लिए होगी?
अगर
ये दोनों को मिक्सअप हो रही हैं कुछ चीजें.
सर, अगर सिर्फ कॉन्स्टिट्यूशन अमेंडमेंट के तहत वो एनलार्जमेंट हो सकती है, तो
जुरिस्डिक्शन जो हैं वो 184, 185, 188, 186A, 188, 204 एंड 203 FE जो है शरीयत कोर्ट की, ये जुरिस्डिक्शन कॉन्स्टिट्यूशन में है. इनकी अगर एनलार्जमेंट होनी है, कैन इट बी डन बाय एनी ऑर्डिनरी लेजिस्लेशन?
sir, because otherwise you will have to read this provision in relation to enlargement as being redundant.
नो, वो एनलार्जमेंट जो है दो तरीकों से ना, दो जुरिस्डिक्शन आ गई. अगर दोनों की एनलार्जमेंट होनी है तो एक इंस्ट्रूमेंट है कॉन्स्टिट्यूशन, दूसरा इंस्ट्रूमेंट है एक्ट ऑफ पार्लियामेंट. तो एनलार्जमेंट करें उसी तरीके से करें, उसी तरीके से करें जिस तरीके से जुरिस्डिक्शन आ रही है.
If we say that the jurisdiction already exists, only to the extent of enlargement has the power been given to the parliament.
Enlargement, the concept of
We
enlargement
have got bogged down in
existence of some jurisdiction.
amendments to the constitution. If suppose parliament tomorrow enacts an amendment and says 184.3 is hereby repealed,